So welcome to this conference, Science and Religion in the Classroom, in honor of the 25th anniversary of the Supreme Court's decision in Edwards versus Aguillard. My name is Michael McConnell. I teach here and am director of the Constitutional Law Center. And so I welcome you all to what I think will be a lively discussion. This is about one of the real flashpoints in the culture wars of the last generation, and one that doesn't ever seem entirely to go away, although it keeps coming back in different forms, like a shapeshifter. It raises all kinds of interesting questions from different disciplinary perspectives. For example, as a matter of constitutional theory, the case raises very hard questions about what we mean by saying that a statute lacks a secular purpose, and Justice Scalia's dissent in the case is one of the classics of the genre in explaining why that concept is complicated and problematic. It also raises a related question of what we mean when we say that the government must be neutral toward religion. Does that mean that it has to give equal time or balanced treatment to religious and non-religious views? How does the government exercise the educative function in a way which is truly neutral between opposing points of view, some of them religious? But it's not all about constitutional theory. It's partly about pedagogy. How do we teach, right? And what is the best way and what are unacceptable ways of teaching controversial material where large segments of the community are in disagreement with the sort of professionally blessed story? How are the dissenters to be treated? And then that leads, of course, to the political question of what happens when the dissenters manage to become the majority in the legislature. So raising the question of democratic control over education. We dance around this question so much as we talk in our over the history of American education of local control, and yet increasingly it's become national control. And how political, how democratic is it? What are the roles of majorities and ordinary people in deciding what the content of curriculum is going to be? Or should it be a professionalized matter? And where do the courts fit in? They are, of course, neither democratic nor are they scientists. And yet, do they have the last word? So with all of these questions in front of us, I think we're going to have an interesting afternoon. This first panel is going to be discussing the history of creationism controversies. The second panel focusing more on Edwards against Aguillard itself and its legacy. The final panel will be on the question of why does this matter? And then we're going to have some concluding remarks by Ed Larson, who's been visiting here at Stanford Law School this half year and is the author of the Pulitzer Prize-winning History of the Scopes Trial called Summer of the Gods. So with that, I turn it over to the panel.
Okay, I'm Lawrence Friedman. I'm the moderator, and I have a very limited role. I'm going to introduce the speakers and see to it that they don't talk too long, and also tell people to turn off their cell phones. Okay, and I'm going to turn off mine. Okay. So our first speaker, and I think I'll introduce, I suppose I have discretion, I'll introduce each speaker, and I won't introduce all of them now. I'll introduce them as they appear. I think that works better. Otherwise, you might forget. So our first speaker is, they're a very distinguished group, that goes without saying. Our first speaker is Professor Ronald Numbers, who is the Hildale Professor of the History of Science and Medicine and a member of the Department of Medical History and Bioethics at the great University of Wisconsin-Madison. one of the great universities in the Arctic, under the Arctic Circle, and he's taught there for more than 3 decades. He's written more than 24 books, very important books in the history of medicine, and science, including Darwinism Comes to America, Disseminating Darwinism. He edited ISIS, the flagship journal of the history of science. He's writing a history of science in America, co-editing the 8-volume Cambridge History of Science. He's got all sorts of awards. He's past president of the History of Science Society and the American Society of Church History. In 2005, he was elected to a 4-year term as president of the International Union of History and Philosophy of Science, the Division of History of Science and Technology. So, Professor Ronald.
Thank you very much. That was very generous of you, except you failed to note my proudest moment.
Which was?
I trained this guy. Everything he knows about writing history of science, you learned from me and many other people. Okay. I've been asked to focus on creation science. And it's important to recognize that creation science is a very distinctive form of anti-evolutionism, extremely different from what was popular in the 1920s, 30s, and 40s. But first of all, I want to prove, or at least argue, that I am the only truly unbiased person in this room. That is, in advance of the Edwards versus Aguillard, I was asked by both sides to be an expert witness. You can interpret that any way you want to. So I was deposed for 2 days, but of course the judge issued a summary judgment, so I never got to testify. The creationist attorney who tried to recruit me was the famous, notorious Wendell Bird, who then deposed me, and he would, during the deposition, he would try to show how ignorant I was about the topic, and then we would take a break, and he would try to save my soul, literally. You know, he knew I was losing my faith. I had been raised a fundamentalist, and so he would take me off and say, you know, please, just because you're giving up this cult, don't give up Jesus Christ as your Savior. And then he'd go back to hammering me. So I have very mixed feelings about that experience. Now, as I said, my focus for the next 10 minutes will be on the distinctive features of creation science, a term that didn't appear until about 1970. So in the 1920s, during the anti-evolution movement, the two popular anti-evolution interpretations of Genesis were both theories, a day-age theory that the days of Genesis represented ages, or that you could put the whole geological column before the first day of Genesis. And those two allowed anti-evolutionists, Bible-believing advocates to accept all of historical geology and a lot of paleontology. There was one tiny stream in the 1920s that came out of Seventh-day Adventism, best represented by George McCready Price, and that insisted that life on Earth was no more than about 6,000 or 7,000 years, later about 10,000 years, and attributed the entire geological column to the 1 year of Noah's flood. So the easiest way to identify creation science is to look at what they do with the Genesis flood. That's the story. Geology in creation science has traditionally been much more important than biology. In 1954, a Baptist philosopher and biblical scholar named Bernard Ram published a book on the Christian view of science and scripture, which just lambasted these hyper-fundamentalists who believed in a very young earth. That spurred a couple of young earth creationists, John Whitcomb, an Old Testament scholar, and Henry Morse, to write a rebuttal called The Genesis Flood, again, geology, not biology, which they published in 1961. It was a major bestseller in conservative evangelical circles. Over the first 25 years, sold over 200,000 copies and stimulated considerable discussion. Now, at first, Morris and Whitcomb focused, as they traveled around the country, on discrediting the other fundamentalist views, the day, age, and gap accounts, before they turned in a few years to focusing on a more positive presentation of what had been called for decades flood geology and became known about 1970, within a few months, as creation science or scientific creation. And that was just a new name for the old flood geology. So what was so interesting about this point of view? Whitcomb and Morris started out by declaring, in the Genesis flood, declaring their total allegiance to biblical inerrancy. That is, they did not think that you could find a single error in the Bible, even when it discussed scientific and historical events. They pointed out that fundamentalist Christians had, for over a century, been trying to accommodate science to the Bible. That's what the gap and day-age theories did. They said, there's no way of predicting where that's going to end because science is going to go on, and then we don't know where this will. They said, let us start out with the clear meaning of the inerrant Bible and see then whether we can find some model of nature that will fit the scriptures. So they flipped the traditional relationship with science. They surprised a lot of people by being among the first, not technically the first, but very close to the first, to present dinosaurs in a positive light. This was based on a very questionable discovery in the Paluxy River in Texas of human giant footprints at the same level with dinosaur prints, sometimes superimposed. And this explained, this helped to justify squishing the entire column, geological column, down to 1 year. But it also clarified for Henry Morris an intriguing passage in the early chapters of Genesis. I think it's Genesis 6. You would know. Is it Genesis 6? You're letting me down, Ed. And Genesis 6 talks about the giants who walk the face of the earth. And it also talks about, those were, of course, the giants whose footprints had been found. And Morris explained that these giants were the offspring of the evil angels that had been thrown out of heaven with Lucifer, very large, powerful, attractive beings. They had been in heaven just a short time ago. And they came down to earth, and they were so striking and compelling that they possessed humans first, and they were so bright and attractive that they could take any women that they wanted. And their children then became the giants of the days of old. So I just mention this because I want to give you a flavor of how detailed they were in their defense of an inerrant scripture. And this, of course, provided the background for the evidence being found at the Paluxy River. At the time this book came out, Henry Morris was a young professor at Southwest Louisiana. He had received a PhD in hydraulic engineering at the University of Minnesota, and shortly after the book came out, moved to be head of civil engineering at Virginia Polytechnic Institute. But he kept feeling that his real ministry now was to promote flood geology. Is that 12?
No, not yet. A minute.
Oh.
You have another minute.
I do.
Okay.
Well, if God could create the world in 6 days, I can finish this in a minute. Yeah.
No, he's the 3 minutes. Right? Oh, whatever. 1 minute. A debate, whatever time.
It'll come out of his, right?
Yeah.
Yeah.
Take it.
Yeah. And his primary justification for defending a literal young earth interpretation of Genesis was not because he thought that was so important. What he and Whitcomb were ultimately committed to was a pre-millennial eschatology. And I don't have time to explain what that is. But it is the imminent return of Christ to earth. And they felt that if fundamentalist Christians interpreted the first books of the Bible as being symbolic, there would be a tendency to interpret the last books of the Bible as equally symbolic and not realize that those were literal predictions of an imminent end of the earth. He came out in 1970 to the San Diego area, and 2 years later established the Institute for Creation Research, which until the last few years and the rise of Ken Ham's Answers in Genesis in northern Kentucky was the international center for promoting not just creationism, but this unique view of creationism.
Thank you. The next, yeah.
Short introduction. No. Short introduction.
I'm going to, no, you deserve a long. The next speaker is Ed Larson. He's visiting here at Stanford Law School, and he's been a wonderful source of knowledge and insight to all of us. He's a Pulitzer Prize winner in history for Summer for the Gods, his wonderful book, one of the many wonderful books he's written. He has an appointment at the University of Georgia, but he's also the Hugh and Hazel Darling Chair in Law at Pepperdine. The Darling, I think, is a name, not a...
It's also UCLA's law library. It's the same people.
He's the author of 8 books, over 100 published articles about science, medicine, and law from a historical perspective. He's a truly distinguished historian, and he will now tell us something.
Thank you. I mean, it's such an honor to be here from all of you, but for me especially, because three of the, in my opinion, the greatest historians in the country are listening to me, which is a little disconcerting, but Lawrence, of course, and Ron and Jack Rakoff up there. And then, of course, one of the greatest philosophers of science right next to me. So I'll try to do my best. I've been given a narrow focus topic, and I've tried to be fairly formal about it to stay somewhat within the time frame, to provide just the background based on what Ron just told you about the development of the movement, the legal history of legislation, of anti-evolution legislation. Of course, Darwinism refers to the theory of evolution devised by the English naturalist Charles Darwin. In his 1859 book On the Origin of Species, it depicts all plants and animal species evolving from pre-existing species over millions of years through the natural selection of variations that in some ways made some individual organisms better fitted to their environment than others of the same species. Just as background, by 1880, virtually all American naturalists accepted the concept of evolution and were using it to understand natural processes of life. Before the advent of Darwinism, however, scientists with strong religious convictions were among the staunchest defenders of the doctrine of divine special creation. As scientific support for creationism waned, some theologians, ministers, and lay Christians took up its defense. By the late 19th century, religious publishers were pouring forth a steady stream of anti-evolution books, and that has continued to this day. And some conservative Baptist and Presbyterian leaders had launched drives to purge denominational colleges, seminaries, and pulpits of evolutionism and other so-called modernist influences. As part of a larger return to normalcy during the 1920s, the ongoing concerns of American evangelicals over the theory of human evolution and its implications for society and religion erupted into a nationwide effort to drive Darwinism from public education. More than any other individual, the American orator, politician, and Presbyterian lay leader, William Jennings Bryan, was responsible. Although he had fought against modernism in his own denomination for years, Bryan did not call for laws against teaching evolution in public schools until January of 1922, when he heard about such an effort in Kentucky and made it his own. Although that Kentucky bill failed, the crusade for anti-evolution legislation quickly spread. Many of the ministers and evangelists who had backed efforts to purify their churches of Darwinian influence enlisted in the new push against teaching evolution in public schools. At the time, most American states had part-time legislatures that only met for a few months in odd-numbered years. Kentucky was an anomaly, meeting in 1922. But when its bill failed, Darwin and his followers had to wait until 1923 for their next big push at lawmaking, which was sort of a scattershot effort around the country. As it turned out, all those bills failed, except a few minor ones that were more limited in what they did. Oklahoma, Florida passed limited restrictions. Now, sobered by these failures, anti-evolutionists focused their attention on building grassroots support in Tennessee and North Carolina in advance of the 1925 legislative session. They reasoned that victories in those states could lead to later successes elsewhere. Bryan and other prominent national anti-evolution leaders spoke in Tennessee on multiple occasions during 1924. As a result of their efforts, teaching evolution became a major issue in the 1924 elections in Tennessee, with many candidates vowing on their brochures and leaflets that they would support, quote, Bryan and the Bible. Well, it worked. And they got a bill passed. The legislators that took office in 1925, first it passed the House of Representatives quietly, without much attention, but then it became a national focus. Pilloried in the press for even considering the bill, the Senate at first deferred that anti-evolution bill. National evangelical organizations responded by sending their leaders and their best speakers to the state of Tennessee during that session, most famously Billy Sunday, who held a major crusade in Memphis that attracted over 100,000 people, and he was pushing this bill. At the center of the storm, the Senate relented and passed the bill on March of 1925. When the governor, Austin Peay, signed it into law, national opponents led by the ACLU and the American Association for the Advancement of Science challenged it in court through a test case involving a Dayton, Tennessee teacher named John Scopes. A media circus pitting Bryan against famed defense attorney Clarence Darrow, the Scopes trial became front-page news around the nation. Despite Darrow's humiliating cross-examination of Bryan, who died while still in Dayton, Scopes ultimately lost the case and Tennessee's anti-evolution law was upheld. In large part, this resulted from the fact that the United States Supreme Court had not yet extended the constitutional bar against government establishment religion to public schools. The pace of anti-evolution activism picked up following the Scopes trial as two more states and many local school districts enacted the theory, eliminated the theory of human evolution from their biology curriculum. The resulting hodgepodge of state and local limits on teaching evolution effectively led most high school textbooks to virtually ignore the subject of organic origins until new federally funded biology textbooks featuring evolution appeared on the market in the late 1950s, early 1960s. By then, the legal landscape had changed dramatically. The change began in 1947 when the Supreme Court drafted the First Amendment bar against the establishment of religion to the liberties protected from state action by the 14th Amendment. Suddenly, the Establishment Clause took on new life. Whereas Congress had rarely made laws respecting an establishment of religion prior to 1947, so there was virtually no case law on point, states and public schools had been doing so right along. Hence, a torrent of Establishment Clause litigation. The first of those cases did not address restrictions on teaching evolution, but they surely implicated them. In a succession of decisions beginning in 1948, the Supreme Court struck down classroom religious instruction, school-sponsored prayer, mandatory Bible reading, and finally, in the 1968 case of Epperson versus Arkansas, the old anti-evolution laws. Now, as Ron has pointed out, those 40-year-old statutes simply banned the teaching of human evolution. They did not authorize teaching other theories. Indeed, in his day, Bryan never called for including any form of creationist instruction in the science classroom because no scientific alternative to evolution then existed. But with the publication of The Genesis Flood in 1961, Henry Morris gave believers scientific-sounding arguments supporting the biblical account of a recent six-day creation. This book and others from Morris's two organizations, the Creation Research Society, or CRS, and the Institute for Creation Research, the ICR, launched a second phase of anti-evolution litigation, the phase associated with seeking balanced treatment for creation science that led directly to Edwards versus Aguillard. Now, during the 1970s, dozens of bills appeared in state legislatures across the country to require classroom presentation of creationist religious concepts as a foil to religious teaching. Their proponents apparently recognized the judicial restrictions against banning evolutionary teaching altogether, but typically did not fully appreciate either the established limits on religious instruction or emerging claims of creation science. Once again, Tennessee provided the first breakthrough. The Tennessee Genesis Bill, which was introduced into the state Senate in March of 1973. It required that all public school teachers presenting a theory of human origins identify the concepts as theories rather than scientific facts. The bill also mandated that text presenting any theory give equal space to other theories, including the biblical account. The idea of the bill came from Russell Artist, a biology professor at a small Christian-affiliated Tennessee college. As members of CRS, Artist, Morris, and others co-authored the 1970 creationist book, Biology, A Search for Order in Complexity. After failing to get this text approved by the Tennessee State Textbook Commission for use as a primary text in Tennessee public schools, Artist offered the book as a supplementary reader, with the Genesis bill being his means to get around the textbook commission. Invoking notions of equal time for alternative theories, the Genesis bill swept through the Tennessee legislature in 1973, only to be declared unconstitutional 2 years later by the Sixth Circuit in Daniel versus Walter. The same year that Tennessee passed its Genesis Act, the State Textbook Commission in neighboring Indiana adopted Biology, A Search for Order and Complexity, as one of 7 textbooks, biology textbooks, approved for use in Indiana public schools. Since all the other approved texts presented traditional evolutionary perspectives, the Commission claimed that the creationist alternative served as a valid means to include 2 views and give local schools the options of including 2 views. What seemed like a fair accommodation at the state level, and in the 5 school districts that did just that, adopted A Search for Order along with one of the other texts, created constitutional controversy when one suburban school district adopted it as the only approved text. After the State Commission rejected ensuing demands to withdraw approval for the creationist text, the Indiana ACLU, then led by the well-known constitutional law expert Robert O'Neill, filed suit in 1974 against the commission on behalf of a local student named John Hadreen. Pursuant to state administrative law procedures, the complaint was referred to the commission for a hearing. At the hearing, the ACLU presented a string of Indiana biologists and theologians who uniformly described the textbook as a sectarian presentation of sectarian beliefs. Based on this testimony, after the commission refused to do so, a state trial court decertified the text. Enraged by these 2 decisions, a Yale law student named Wendell Bird turned his attention to designing a new strategy for the creationist movement, which he published in 1978 as a long student note in the Yale Law Journal. Starting from the proposition that several religious denominations affirm divine creation as a cardinal tenet of faith, Bird revived the by then familiar creationist argument that teaching only evolution violated the free exercise of such religions by compelling public school students from those denominations either to receive instruction in heretical views or to forego biology training. Applying the constitutional principle that the government may not restrict individual rights more than necessary to achieve its objectives, Bird then proposed that when furthering the goal of biology instruction, schools should neutralize their curriculum by teaching both creation and evolution. Thanks to the arguments already put forth by Henry Morris, arguing that creation science had scientific evidence and not just a religious basis, he then could argue that doing so would not violate the Establishment Clause because it could only be the scientific part of creation science. Therefore, it furthered the Free Exercise Clause while not violating the Establishment Clause. After graduation from Yale, Wendell Bird joined Henry Morris at the Institute of Creation Research as a staff attorney, and there he wrote a model school guidelines to be adopted by public school districts that encapsulated his arguments from this Yale Law Review and mandated or authorized balanced treatment for creation science and evolution. Well, just to quickly get us to this case, this, as quick as I can, This model statute was then distributed by the thousands by ICR around the country. One of the persons who received it was a person named Paul Ellwanger, a private citizen who had battled evolutionary teaching in his own state for South Carolina for years. And he turned Byrd's resolution into a model state statute, which he then tried to pass in South Carolina. It failed in South Carolina, but he sent it out. And it's that language that reached Arkansas, and it reached Louisiana. In Arkansas, it was passed almost verbatim and became the subject of a lawsuit there. The same year, 1981, it reached Louisiana and was submitted there. In Louisiana, at first the Senate modified it, cut it back to sort of an optional approach that could be considered. The House, though, turned and whipped it back into something more akin to the balanced treatment, mandated balanced treatment that Byrd had proposed for local school districts, and then Ellwanger had turned to be a state mandate imposed on local school districts. This was the law that was signed by Governor David Treen in July of 1981. And it was these two laws that the American Civil Liberties Union challenged. The first one was the Arkansas law, which was a cleaner statute. It was almost directly Byrd's old law applied to the states. That led to a lengthy trial in Arkansas, which in 1982, Judge William Overton ruled that the act was, quote, simply and purely an effort to introduce the biblical version of creation into the public school curricula, and on that basis, he declared it unconstitutional as religious instruction in the schools. The state never appealed. The second case that was filed as Aguillard versus Treen, but eventually became Edwards versus Aguillard after Don Edwards replaced David Treen as the governor, never went to trial. Ruling in response to the plaintiff's motion for summary judgment in 1985, Judge Adrien Duplantier declared the Louisiana Act unconstitutional for, quote, promoting the beliefs of some theistic sects to the detriment of others. After the Fifth Circuit Court of Appeals upheld Duplantier's ruling, the case went to the United States Supreme Court. His 1987 decision is the subject of this symposium, and that I'll lead to the next panel. Thanks.
So the next speaker is Michael Ruse, the Werkmeister Professor of Philosophy at Florida State University. He taught in Ontario, Canada for 35 years, and since then he's been at Florida State. He was elected as a Fellow of the Royal Society of Canada in 1986 and the American Association for the Advancement of Science. He has honorary doctorates from the University of Bergen, Norway, McMaster University in Ontario, and most recently the University of New Brunswick in Canada. He was a key witness for the plaintiff in the 1981 test case, McLean versus Arkansas, of the state law permitting the teaching of creation science in the Arkansas school system. The federal judge ruled the state law unconstitutional. Mr. Ruse, with other scholars, delivered the 2001 Gifford Lectures in Natural Theology at the University of Glasgow. His lectures on evolutionary naturalism, a Darwinian understanding of epistemology, and a Darwinian understanding of ethics are collected in the volume The Nature and Limits of Human Understanding, which appeared in 2003. Thank you.
Well, after that introduction, I think I'll just shut up now, because anything I say is only going to be downhill, isn't it? This is going to be a little bit personal, as Ron Numbers will tell you. It always is with me. If I'm not talking about myself, I'm not interested. But some background. Why me? I grew up in England. I grew up as a Quaker. I guess I lost my faith round about when I came to North America in '62. I guess I knew about American fundamentalism, American literalism, but you know, it always seemed to me to be something a little bit like Prohibition or Al Capone. It was part of your history, and it's fun to read about, but, you know, you can get a drink now, and, you know, Al Capone is dead. It became clear, though, in the 1970s that Al Capone may be gone and we may be able to get a drink, but that American biblical literalism, as Ron says now called creation science, was alive and well and kicking. And one of the techniques that Henry Morris and his sidekick, Duane T. Gish, author of Evolution, the Fossils Say No, over 150,000 copies sold, was to go out and invite local evolutionists to debates. And so they would come up against the local evolutionists who had absolutely no idea what they were in for, because Morris and Gish would absolutely make fools of them. Apart from anything else, as you've seen from the last two academics, most of us have a lot of trouble staying within our time limits. And so when we're just about to get into natural selection, and the moderator would say, well, thank you very much, now it's somebody else's turn, and they would be apocalyptic, and of course the votes would be taken, and the votes would be something like you'd get in North Korea, you know, 550,000 in favor of creation science, 3 in favor of evolution. I had the first experience of this, I think, in 1977, when I was recruited to go to Northwestern, and I and another biologist debated Morris and Gish. And I found to my surprise that I had the kind of personality that loved this. I realized very quickly that a good joke was going to be worth 10 arguments, and that there was absolutely no point in talking about science because nobody else was talking about science. But if you could get a couple of good riffs in, it did pretty well. I think we went from 550,003 to 550,005 by the time I finished. But more seriously, it did become apparent, and I think to me and to others, that having a background in history and philosophy of science wasn't a handicap, that in fact it could help, particularly I think at that time the history of science, because so many of the arguments that these people were using were arguments that had been used against Darwin and Huxley and Asa Gray and all of these people. And so when they started trotting these out, it was, to use a term, it was manna from heaven. Because this, you know, once they got into something to do with molecules, well, I'm a philosopher, God forbid, but as long as they stay with your gaps in the fossil record and this sort of thing, I'm happy to do it. Well, as Ed has told you, if we can, shall we say, creation science went on maturing, and in 1981, the state of Arkansas, in its wisdom, passed this bill into law. If you remember, this was the Clinton interregnum. For the first and only time in his life, he'd been not president, he'd been governor in 78 to 80, lost it, and a man called White took over for 2 years, and then Clinton came back. And I think White was as surprised at getting the job as he was inadequate at doing it. So it was passed, and at once, as I discovered, the ACLU swung into action. Now, why me, a philosopher living in Canada with a funny accent? Well, I mean, particularly since they were really going for the heavyweights. I mean, they got Steve Gould, for instance. They got Langdon Gilkey, the eminent theologian. They asked Carl Sagan. Both of his wives deny this, but Sagan didn't think it was worth his time until almost the last moment when he realized it was going to be a big-name thing and said, I am available. And they said, well, sorry, but we don't want you. Why me? Well, what they did was they started asking around, and as these things go, you have a conversation with somebody, and then you say, well, can you give me 3 more names? And they start to crisscross. And it became very clear that they didn't want the brightest. They didn't want somebody who'd spent 10 years at Stanford doing S knows the P, or that sort of thing. They wanted somebody for whom a good joke is worth 10 arguments. And so I was asked, I should say, all of the time from, as I remember, early September to the time of the court case, which was early December, every conversation I had with the ACLU lawyers went along the lines of, we're not at all sure we're going to use you. They themselves were saying, why on earth would we need a philosopher? Obviously we need a theologian or two. Obviously we need a scientist or two. Obviously we need some people in education and that. But why a philosopher? And others kept saying, because so much of this debate is going on about philosophy. Both sides, as we've heard, both sides tried to recruit Ron Numbers. Both sides had already recruited Karl Popper in name, not in person. And both sides were, it was flying thick and fast. I'm more falsifiable than you. Oh, no, you're not. Look at this daft thing I've said. This is really falsifiable. Ah, yes, but what a... And so every now and then the name of Kuhn would come up, but that gave them the kind of willies. But Popper, oh boy, Popper was the flavor du jour. So, in the end, they did use me. Ed's went round and interviewed people. On the first day, in the afternoon, Langdon Gilkey, the theologian from Chicago, was there. And as Ed said, I've learned, and it was certainly true, he was the one who really knocked the hell out of the other side. He got up there, he had a deep voice, he got beads, he got, and he was a showman beyond compare. And when he was asked questions, he said, yes, that's a very interesting heresy. I think that was first mooted in 305 AD. Now let me tell you, no name for it, Professor, let's move on. I was put on in the second morning on the Tuesday morning, and I think I had about half an hour spirited direct examination, which most of it had been very much as I was being prepared for my divorce case. Don't talk too much, Mike. Stop the jokes. Just get on with it. I know you want to talk. Just get on with it. And we went through it in about 30 minutes. And then a man called Williams, who was the Deputy Attorney General, got up. And we spent the whole morning on the stand and a good chunk of the afternoon too, because it became very clear that they thought that this was the weak point. I mean, it was no credit to me. They felt very much that if they could get me, then they wouldn't necessarily win, but they'd gone a long way to winning. And I can still remember it going on, and he started into my religious beliefs, and he went on and on and on, and I finally blurted out, and I said, Mr. Williams, surely you can see I'm not an expert opinion on my witness on my own religious beliefs. And of course everybody laughed, and he started again, and Overton said, move on, Mr. Williams, move on, he's not going to give it to you. It did become clear in the course of that debate that what was going to be very, very important was the whole notion of what science is. And I mean, really, that is where a philosopher is important. And if you look at it, you see I gave a sort of compendium. It's something which obeys natural law. You have explanations by these laws. It's testable. It's tentative. And dear old dear, it's falsifiable. And immodestly, I'm very glad to say that went right into Overton's judgment, and I like to think that that's been very important since. It wasn't appealed. I always thought it was because the state didn't want to appeal it. The state was just at the point when they were trying to move into the new era. They were trying to attract things like high-tech business and that sort of thing. And, you get a bright young engineer down from MIT, and you say, well, what's it like down here? And they say, well, the crime's pretty good, it's pretty good, the living conditions are good, the winters are not bad. And then they say, what about the schools? Oh, schools are pretty good. Of course, we teach creation science, and of course, what they do is go on to some place like Arizona, which believes the same stuff, but which are bigger hypocrites and are not going to put it in the schools. So I always had the feeling that the Attorney General was not going to push it. One final thing, though, the people who were really displeased with my performance was my fellow philosophers. And boy, did I ever walk into it, one after another after another went after me. And, you know, it wasn't any good saying, folks, this is not a philosophical seminar, this is a court of law. They thought that I had really sold the profession down the thing, which was nice because then they write articles and then I get to write an article against them, and my CV swelled and swelled and swelled and swelled. So, anyways, we all did have a very good time, and I'll just end with one lovely, lovely, lovely note. The late Father Ernest McLean, who was a professor of history and philosophy of science and a dear, dear man at Notre Dame, was one of the people who was most critical of me. And a couple of years later, a man called Alvin Plantinga, who was a Calvinist from Calvin College, was appointed to Notre Dame. And Plantinga is an ardent, intelligent designer. And after 10 years of having Plantinga as a colleague, Ernest came to me and he said, Mike, I owe you an apology. Thank you.
So our next speaker is Patricia Bowers. She's a private practice in New Orleans. She specializes in complex civil and constitutional litigation, appellate litigation, disputes over attorney's fees, high-profile criminal defense, if anybody here needs that. She served 10 years as an assistant attorney general in the Louisiana Department of Justice, and she was responsible for the state's defense of the balanced treatment law at issue in Edwards versus Aguillard. She's a graduate of Vanderbilt University and Tulane Law School, and you don't look old enough to have been involved in that case.
63 is not old enough?
Well, let's not get into that.
Let's just say I have a very good hairdresser. You're going to have people talk to you, already have had people talk to you about the details of the science and what went on. Being a New Orleanian, where we're famous for local color and debauchery, I'm going to talk to you about sort of the background stuff of this case so that you can have a flavor for what was happening. There were 3 cases going on at one time, one in the Eastern District of Louisiana, one in the Middle District, and one in our state civil court. The one in the Middle District and the state civil court fizzled out, but not before the one in the Middle District. The federal judge threatened to put me and the Attorney General in jail. And the one in state court, we got to go to the state court judge's house for his 50th birthday party and drink champagne while arguing a TRO. So the rest of the case was sort of downhill from there. But the main case in the Eastern District of Louisiana was handled by Adrienne Duplanche, who very definitely was very bright and the brightest judge on the bench and a former powerhouse in the state legislature. He knew Bill Keith, who had authored this particular bill. I specialized, just like I do now while I was in the Attorney General's office, in complex litigation and civil rights and constitutional matters. And in that capacity, I had handled for the Attorney General the defense of 2 abortion regulation statutes, which Bill Keith was also the author of, and prayer in school and things like that. Louisiana is very definitely divided into 2 zones. There's and I hope I'm not going to offend anybody here, but there's the North Louisiana, very religious, very straight area, and then there's the evil, sinful, fallen away Catholic New Orleans. You know, we have all the fun Catholic traditions, but really nobody follows the laws of Catholicism, just sort of the festivals. For political reasons, which I'm not at liberty to discuss, they're part of a confidential relationship, the Attorney General of Arkansas decided to handle the case himself. He was the lead counsel. I believe he was offered help from Wendell Bird, etc., and he turned that help down. When it came time for our case, Wendell and crew came to my Attorney General, Billy Gust, was a very religious man himself. He belonged to some order called like St. Francis or something, where he had been appointed by the Pope. And when he got dressed up to go to one of those meetings, he looked like an Irish cardinal in that he'd have on a tux and a cape, like a red cardinal cape, but emerald green. And so he was very religious, and he wanted to do a good job with this. And Wendell and his people came in and offered their help to the state of Louisiana for free. Whether they were paid by somebody else, I have no idea. I have my suspicions, but I have no idea. I know I never saw a bill, and I was in charge of the case. But part of what I want to talk to you about is what it's like to be the local scene of a case that's on the national stage. You're trying to manage the case. You've got to do business here with this federal judge and this legislature and this governor and this attorney general next week and next month and next year. And you've got two sides. Your side, where you've got help that's come in and volunteered to help you, and you've got the other side. The other side was represented by Paul Weiss Rifkin out of New York. And I mean, as you all know, they're real heavy hitters. And so both sides were so committed that they would say or do anything to win their case. Well, Adrian Duplanche wasn't real keen on having lawyers come into his courtroom from out of town and say or do whatever they please, and sort of take things to the edge. And my attorney general was not pleased with that concept either, because of this thing of having to continue to do business there afterwards. So whether Adrian Duplanche and my attorney general had a drink somewhere and got together on this, I don't know. The way we do business in New Orleans, I wouldn't be surprised. But an order issued from Adrian Duplanche saying, we have a technical term in the Eastern District of Louisiana, maybe y'all have it wherever you're from, called the trial attorney, and that's the person that's responsible to the court for anything that's said or done or not said. So the Attorney General appointed me to that position. And what that involved was, he called me in, he said, Tricia, I want you to handle this scientific litigation, creationism. It's going to have a lot of politics. It's going to have a lot of press. You have a lot of background with that because of your earlier handling of other sensational cases. And he said, as always, if you have any personal philosophical objection, I'll excuse you and appoint someone else. I said, well, General, I'm glad to do that for you, but could you tell me what scientific creationism is? And that, so I take issue with you. I'm the person that knows the least about this. But eventually I got into it. My Attorney General decided to accept the help of Wendell Bird, etc. Wendell insisted on being lead counsel, but he was knocked out of that role by the order of the judge. Although he was, from a legal point of view, the lead counsel in that he found the witnesses, you know, he took the depositions. We decided together, the Attorney General and Wendell and his crew and I, that our chance here, knowing we had an uphill battle, our chance was to say that the height of education is to let people read anything they can get their hands on and then make up their own mind. This sat real well with me because I come from an Irish immigrant family. My grandfather died in the coal mines coming here from Ireland. And my father always took the position. My mother would be hyper because we'd be reading some piece of trash. And my father would say, no, let them read anything they can get their hands on. And that's the way they'll learn to discern and to see what's good and what's bad and form their own opinion. So I came to the litigation with the idea that that's what you do. If you've got a controversial topic, you say, here, read this, read this, read this. 90% believe in of credible scientists believe in evolution. 10% believe in scientific creationism. I don't know what these gentlemen have spoken about how reputable Wendell's specialists really were. I can tell you that they had credentials from here to the door. But that was the way we went. We thought that was our only chance to say, let all voices be heard. And so we went with that, and y'all all know the history of the litigation as it came out of the Eastern District. We lost a motion for summary judgment. We lost on in the Fifth Circuit. We lost on a panel rehearing, and we lost at the Supreme Court. But I still personally hold the belief that the height of education is to let people read whatever they can get their hands on. But my role as we went through the litigation was, because I had been appointed by the Attorney General and Judge Duplanche, and I had a counterpart on the other side. John DiGiulio was a local boy, and he ran the case for the plaintiffs. And so what that devolved into was that Wendell and his people couldn't sign any pleadings. They had to send them to me, and I read them with a red pen in hand, and we edited them up a little bit and then filed them. For instance, Wendell's most favorite word on the planet is wrong-headed, and he refers to judges as being wrong-headed, sometimes 25 times in one pleading. Well, I don't want to go over next week and argue a case in front of Aguillard and Duplanche about $100 million for old people and have him say, Ms. Bowers, you still think I'm wrong-headed? You know, so wrong-headed always came out. And it's always a challenge. You love it that you've got somebody that's got, that's made this their life history, that you've got them to help you, because obviously you don't have 5 years to come up to speed on this topic before the case goes to trial. But your agendas are different. The person who's crazy in favor of scientific creationism or crazy in favor of evolution or make it anything, abortion regulation, non-abortion regulation, prayer in school, non-prayer in school. My experience has taught me that you could tell people facts for 100 years on any one of those hot topics like that, and they'll have the same opinion when you shut your mouth as when you opened it. And so it makes it very difficult, because the Attorney General's job is to defend what the legislature passes. It's not to say, gee, I think this is a lovely law, or I think this is a bad law. And the Attorney General's job is to continue to do business in Louisiana with all those federal judges. Whereas the scientific creationism people are on the other side. My new friend, the former head of the ACLU's, their job is to do anything they can do to get their side passed. And so it very much becomes a two-agenda thing on both sides of the aisle. And so it was my unlovely task to try and coordinate those agendas and to deal with the press, because the Attorney General did not want somebody who was not a member of his own staff speaking to the press. And it proved to be a fascinating case. I thoroughly enjoyed myself. I did a lot of management work on the case, too, in the sense that at one point we were taking depositions 18 hours a day, 7 days a week, 3 simultaneous depositions for several weeks in a row. So it was, I put a few gray hairs in there that now the hairdresser has to cover up. And I guess the only other thing that I would tell you is I would suspect very strongly that the judges on the Fifth Circuit knew Bill Keith's reputation as a state legislator from North Louisiana who was affiliated with the religious right. and for damn sure Adrian Duplanche knew it. And I think that that entered into the way they ruled about whether the case had a secular purpose or not. But I walk away from the experience still thinking, if I had a 12-year-old sitting here on this topic, I'd say, look, 80% believe in evolution, read this stack of books. 10% believe in creation, read this shorter stack of books. And another 10% believe in a variety of stuff, read these 3 books, and then let's talk about it when you get through. And to the extent that this case contributes to education not being that, I don't like it. Not because I'm one way or another on scientific creationism. I guess the last thing I would say is I was surprised, I guess I was naive, to find that, and y'all probably all know this because I think a lot of y'all are educators, but within the educational field, at least in Louisiana, there are cliques, and there is definitely what's politically correct, and there is definitely what's not politically correct. And believe you me, in Louisiana, at the time, evolution was politically correct, and those people from the Board of Education who were making up their minds about what was going to go on the agenda, they didn't even want to hear word one about that you might teach alternative theories, whether it was scientific creationism or the man in the moon. So it was not quite as narrow as the case is presented. I'd be glad to answer any questions if anybody has any.
Thank you. So now we, unless any members of the panel want to add anything or subtract anything or retract anything, we can.
I do.
You do?
Yes.
Okay.
This is addressed to Michael Ruse.
Oh, thank God it's not me.
I thought you told a very partial story. And I don't think anybody, probably most people here don't know that a number of years after his crucial expert testimony in Little Rock, he repudiated it all. I have a transcript of his talk where he just says he doesn't believe it at all. Now, which is the real Michael Ruse? Were you gaming the system?
I don't think I went back and looked at that, and I don't think I was repudiating it at all. What I think I was saying was, of course, in a court case, you can't put in the footnotes that you put into a learned article. So yes, obviously, I do think that, for instance, that science is falsifiable. But I obviously equally don't think that any scientist, let's say on this campus, who's working with the double helix, comes up with a new finding and immediately says, whoops, double helix is falsified. Of course you don't. You keep pushing and pushing and pushing and pushing until death by 1,000 qualifications. So I think the answer to your question, Bob, is, like all good philosophical answers, yes, no, and maybe. That I think that what I said in Arkansas certainly genuinely represents what I think about science. On the other hand, if I were writing even a textbook, and certainly if I were writing, let's say something for the Stanford Encyclopedia of Philosophy, then I would clearly want to put in a huge amount more about what you might mean by falsifiability, what extent there are metaphysical. I mean, Popper himself, for instance, says all science has metaphysical assumptions which can't be falsified. So I think to give you the bigger picture, I think you've got all of that. But as far as I'm concerned, what's your name? Ron. As far as I'm concerned, ultimately, I think evolutionary theory does fit this, that it is trying to explain through law. And I think ultimately creation science doesn't. Now, my critics immediately said, oh yes, but creation scientists can roll with the punches. And it's true, because if you look at the exhibits in Kentucky at the Creationism Museum, it's a lot more sophisticated than Genesis Flood. And they clearly have rolled with a lot of the punches. And I mean, if you look at Philip Johnson on intelligent design, he too says, oh, I'm not even going to go there on, what was it, gaps in the fossil record or something like that. He says, you know, I'll give you that one. So clearly, at some level, but ultimately, and I think as you said, ultimately it's religion and they're not going to give it up. How's that?
So
Nice.
we can now, well, I want to say one word, then I'll let the audience speak. Like so many other issues, a lot of it depends on just the very simple basic fact of federalism. One reason why you don't have this kind of controversy in a lot of other countries is they're not federal. And we all notice that none of these cases come out of, shall we say, Vermont or California. And they're cases that have a regional basis to them. And because the particular states, and indeed within the states, particular boards of education and so on, have a lot more control than would be true in many countries where there's a ministry of education that sets a curriculum and makes decisions for the whole country. So that's something in the background that we have to keep in mind. So now the audience, and there are mics at strategic locations. Please.
So this is a question for Patricia Bowers. No, so I'm just curious about two things. One is, how unusual is it to have basically an activist like Wendell Berry come and more or less run the details of the case, be maybe an arguer and getting the witnesses and things like that. And then do you think it helped the case for the creationist side or hurt it? Because on the one hand, you know, his interests aren't the same as the state's interests, but on the other hand, he's probably a more passionate advocate. And you mentioned that each appeal was lost, but I think, was it the en banc appeal? It was 13 to 12 or something like that, so it was a really close thing. So your thoughts on that?
It's highly unusual to have someone come and volunteer their services. In fact, I own and run a small boutique firm now where I do the same kind of work I did when I was in the Attorney General's office. Even though I have 4 or 5 attorneys working for me, we only handle 10 or 12 cases at a time because they're cases that take 7 or 8 years and go to the Fifth Circuit 3 times and all that. I have to say, I've been practicing 38 years. I don't believe I've ever had that happen before. And I'm sorry, but I'm having a senior moment. What was your second question?
So the second part was, do you think having an activist in that role, do you think it helps the creationist side of the case or hurt it? Because on the one hand, it would be more, you know, extremely committed to the case, right? And a very passionate advocate. On the other hand, might not have the big picture of the state's interests.
Well, that's why I was there, to have the big picture of the state's interest. But I guess overall, I would have to say, since my job was to make sure that the Attorney General was taken care of, that part got covered, even though the people that were helping us were probably more passionate advocates of the statute than the Attorney General was. But on the other hand, I mean, Wendell Bird and his cohorts had made a study of that for 10 years, 20 years, I don't remember anymore. There's no way in the name of God, even if they had taken every one of my other 10 cases and my 3 associates away from me and said, okay, Tricia, handle just this, I would say it would take me a year to come up to speed to know who should I call for a witness, what are the issues. I handled one case in New Orleans for 20 years as lead counsel over prison conditions in the Orleans Parish Prison, which is was a notorious hellhole. and it had local prisoners and it had state prisoners due to lack of state beds in it. It took me 6 months before I understood what they were talking about when I sat at a status conference. The issues were so complex. And this, because I'm not the science queen, would have been more so. It would have been very hard for me to do the science part of this. I mean, I guess I could have scoured the country once I could have figured out what the hell the issues were and hired myself an expert to do in effect what Wendell did. But this is the way it turned out. The Attorney General was not inclined, for a variety of reasons, which again I'm not entitled to go into, to turn down free help.
If I can add one thing to that, and Patricia can certainly correct me if I'm wrong on any of this, but from my conversations with them, the Attorney General of Louisiana was very influenced by what had happened in Arkansas. In Arkansas, the Attorney General, I think it was Steve Clark was his name, turned down Wendell Byrd. Wendell Byrd wanted to come there. He turned him down, and because that was actually a cleaner statute, because it was much closer to Wendell's, it was actually closer to Wendell's original one. And Steve Clark wanted to run it himself. He didn't want somebody else running it. And when he lost, he was vilified. The blame was put on him for losing it, for not putting, I think Steve Clark put a very effective case forward. He learned the stuff. He knew who the right witnesses were. Some of them pulled out. But there was a concerted effort to vilify him. On Pat Robertson, blamed the loss on him on national TV. Eventually a lawsuit was brought by Steve Clark against both Robertson and Jerry Falwell for what they said about him, the slander and the libel, and blaming the defeat on him. And the Attorney General in Louisiana didn't want to be in that position. And letting Wendell Byrd run it says, okay, you can run it. You know, you can have your say here, and therefore he's not going to take the blame like Steve Clark did. Steve Clark ended up in jail. On a different basis. On a different basis. It was related. There's a related, because the accusations they started turning on Chief Clark was that he was having meals with the ACLU and inviting them and going out with them. And it was on the use of his expense of court. That's what the charges were, because I've heard them. I've heard what was being said about him, and it was his use of his expense account that he finally ended up in jail.
So Mike McConnell handed me a little note which I want to read. He said, "You might want to mention that Wendell Byrd was invited to this conference. He's obviously not here, as far as we know."
My comment in response to what you said is that I cannot comment because of attorney-client privilege.
I remember Steve Clark, though. He was awfully nice. I mean, he really was a very nice guy. But his assistant was Williams was, you know, a real bulldog, and there's no question that they really took that case seriously.
Oh, I think they did.
And certainly, the thing was, after they dealt with me, they whipped through Francisco Ayala and particularly Steve Gould as fast as they could on the Tuesday afternoon, because they knew they were going to go after the teachers and the educators on the Wednesday, and by God they did. I mean, in other words, I think they saw very quickly that they weren't going to get a lot of mileage out of all those, you know, people from up north, and that they would do much better. I mean, Steve Gould, you know, was all set to spend the afternoon talking about gaps in the fossil record, and he ended up as one.
Thank you for this historical perspective, and it's fascinating. I'm developing World University in School, like Wikipedia with MIT OpenCourseware. Wikipedia is in 284 languages, and we'd like to accredit on MIT OpenCourseware for online degrees, potentially in many languages. We also like to have an IB school. So my question has to do with the effect of the internet on potentially some of these questions. Would it be true that in some years our International Baccalaureate school would be illegal to teach evolution, potentially if a state legislature went that way, in specific states, but could potentially across the country or even, yeah, so that's my question.
Ed, you have to answer that.
I think that's a question more appropriate for the other panels. I wouldn't see why. I guess it would depend on what the statute said, but I couldn't see a problem with that. But yeah, right. I would think that it would. I wouldn't see. I can't conceive of what the problem were, but I don't know all the facts, and I don't know what statute you're dealing with. But I can't imagine that there would be any problem with that.
I guess I would say that you should
Yes.
that you should seek paid professional advice before you take a step.
Yes, and I'm not paid professional advice on that.
Well, you know, I have one last thing that I forgot to say. I forget whether somebody told me this at the hotel this morning or at the luncheon, but they told me that, or one of y'all were talking, and that said, oh, it was you, said that you would get hammered in your deposition, and then in between Wendell would try and convert you.
Yeah.
One day we had a very long day in court, which included both Baton Rouge and New Orleans, and so I invited all the guys back to my house and said, I'll give you some dinner, but you have to help fix it. And my husband was a lawyer too. He's deceased now, but so he was there and he was helping fix it. I said to Wendell, and here, would you pat these lettuce leaves dry? And he looked at me and he said, are you serious? And I said, yeah, I'm serious. Everybody's got to do something. We're all exhausted. We've all been in court. You want to eat? Start patting those lettuce leaves. So I guess when Wendell came to New Orleans and realized he was in the home of the bad people, he never made any attempt to convert me.
Oh, yeah.
And of course there was the lettuce leaf, so that made me worse.
I was vulnerable spiritually.
I was just going to ask Michael Ruse if you would tell us a little bit more about the substance of the philosophic critiques you had about your testimony.
Oh, you mean on that Tuesday morning and those things?
Well, you said that afterwards you had this...
Oh, I see, yes. Well, basically, it's the same sort of things that Ron Numbers was saying. I mean, you take the question of falsifiability. It's a very popular term, you know, real science is falsifiable, psychoanalysis is not, that sort of thing. I mean, well, that's the Popper's example. Of course, what we philosophers have done is gone backwards and forwards over this. And particularly, remember, we're talking now in an age of Kuhn, where Kuhn says the very last thing that a scientist doing normal science does is let any empirical evidence whatsoever change your opinion about the truth of the paradigm. Well, you know, both sides are exaggerating, obviously. But as I said, it's very clear that in doing science, you can't do science if by 10:30 in the morning you've dropped your scientific theory. And because you've got, you know, well, we saw a perfect example just recently, didn't we? Where these people, was it in Italy, thought they'd got evidence of light or something traveling faster than light. No, it wasn't a question that, I mean, first of all, don't forget authority comes in. If I said that, nobody would take any interest in me. If some grad student at FSU said that, nobody would take. But these were people with real street cred. And so everybody said, well, clearly it's something we've got to look at. We don't believe it. We don't, I mean, it was like cold fusion. I mean, you know, I remember cold fusion, somebody saying it would be like, you know, using a pat of butter to hammer a nail into oak. It can't be done. But it doesn't mean to say that you don't go out and look at it and worry about it and worry about it. And of course, every now and then, and I still remember a man called Philip Sharp, who won a Nobel Prize, to drop names, said, every now and then, twice in my career, something hasn't worked. And he said, I've had a nose that there's something important there. And you do, yeah, so you do falsify. But if you look at Popper himself, he's a lot more sophisticated. He recognizes that. And as I said, Popper is the first to say all scientific theories also have a metaphysical component that you're not going to falsify, that it's not up for grabs. And I think he mentions atomism as an example, that you make a certain commitment to the way that the world is, and that's part of your philosophical background, if you like, like no miracles. I mean, it's just, you're not going to allow, and Eugenie will bear me out on this, because to a certain extent when we're dealing with intelligent design, are folks like us simply saying intelligent design is not possible? Or are we saying, yes, we're prepared to look at it and see if it can be falsified? You've always got this sort of thing. So that's the kind of thing that my fellow philosophers brought up. And are all explanations by law? There's always been a big discussion about this. What about unique events? How do you explain, say, the Big Bang or the demise of the dinosaurs, which is a unique event? Can unique events be covered by law? I mean, if there's only one case of the demise of the dinosaurs, then how can you have a law? I mean, laws are things which apply to that, which also apply to that, which also, and so on and so forth. So, as I say, the whole discussion, any philosophical discussion, gets very complex very quickly. And it's the problem you have with teaching undergraduates. And perhaps this was one of my strengths and also my weaknesses. I've taught a huge number of undergraduate courses in my career, and I realize that you can't teach undergraduates, particularly early ones, by putting in qualifications. You've got to get on with it. I mean, I remember one of my colleagues was the worst teacher that we ever had. He'd get into the paradoxes of confirmation in lecture 2, and by week 13, he'd still be in these bloody things. And the kids would be looking at him like that. So I'm not putting down law or being on a witness stand at all, but I'm saying that your job is to get the information across and make the points, and that was what I was doing. And obviously I was pretty carefully coached on doing it. I don't think I was lying. I really, truly don't think I was lying, but I was fully aware that there were footnotes on footnotes. And of course, some of these did come out in the course of the morning, and you could see Overton sort of yawning at that point, because he'd written down the 5 points, and he got what he wanted. Yep. And no, it was true. And after that, well, when's lunch?
Okay, Ronald, you wanted to say something?
Yeah, my experience bears on this question. I went in with the ACLU attorneys the night before I was giving my deposition. And I was very uncomfortable with this essentialist approach, that the way you decide science and non-science is by falsifiability, because there are instances, as you just pointed out, where that doesn't hold. I and many others, including some of his critics, preferred to argue that creation science was just lousy science. You know, the biology, the physics, everything did not support it. And I was told very late that night by the attorneys that I was worthless. And I said, well, what do you mean? And they said, it's not unconstitutional to teach bad science. So they narrowed everything down. The only way you could have been effective was to do this pseudo-philosophy. Am I privileged at Stanford Law School to give somebody the finger?
May I ask a question? How many people in this room are attorneys? Okay. Well, as you all know, but the rest maybe don't, part of what's going on between these two gentlemen is when you have a case that's going to court, you have to simplify, 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 simplify. I practice my opening and closing arguments, and I give I do a lot of motions for summary judgment because I practice almost all in federal court. I give all that stuff to my secretary and all my non-lawyer help in the office and put it in front of them. And if they don't understand it, then we simplify again. So part of what's going on here with this back and forth is the need to simplify if you're going to court. And
one other thing was, don't forget the term falsifiability was was there on the table because both sides had been using it extensively. So if we hadn't bagged it first, they would have done so.
Well, in that respect, if I know Wendell Bird is an excellent attorney, in my opinion. And he knows this subject very well, and I got to know him well when we lived in Georgia together. His Yale Law Review Journal article, which was the fundamental basis of his argument in Louisiana, and actually many of the findings are in the original statute, which those get cut out in Louisiana. They're still in the statute in Arkansas. They get cut out in Louisiana in the Senate. But they invoked Popper. They invoked falsifiability. They invoke Kuhn. They invoke a lot of philosophy. In their fundamental argument that he's making is that creation science is as scientific as evolution. It's not, he didn't quite say it's science. He says it's as scientific as Darwinism, and Darwinism is as religious as creation science. That's his parallel that he's always working. That's the parallel that was in his Yale Law Review article. It's where he differs. It's what he brought to the Institute of Creation Research. It's not quite what Henry Morris argued before. It's what was argued here, and it's the fundamental issue that was at stake that these people, as expert witnesses, had to deal with. So that was there. That's what the ACLU was dealing with. That's what the judge was dealing with. And that's what ultimately the Supreme Court had to in part deal with, because that was the thesis brought forward.
And is that because both, under rules of science, are really just theories?
Well, that's what they're going to talk about later, but that's the issue that's confronted.
Okay.
We've got to get on.
So this is a two-part question, except I think the second part is for one of the later panels, in fact, but I'd like to ask a historical question to this part, probably particularly to you, Professor Larson. All of my sort of higher education career, and at this point I've been at it long enough that you could call it a career, has been in states where there would never really be a debate about creationism versus teaching of evolution in the schools, or at least in university enclaves where those wouldn't be an issue. I am wondering from this panel whether there's any history in other parts of the nation to push creationism in higher education. And the follow-up for maybe later in the afternoon is there was recently an article published, I want to say it was the Chronicle of Higher Education, I'm not sure about that, where a biologist was arguing for a number of reasons to simply give up on teaching evolution or creationism in high school biology classes. Among the reasons is it's often taught very poorly. And then, so my question for later would be, if that were to be something that became a tactic or a strategy, do you think we would see pressure on higher education that is now being imposed on public schools, primary schools?
I'll be brief on answering your question because you have Eugenie Scott later, who is probably the best expert in the nation monitoring what issues actually come up at every level of this. And she can present, she has a side in all this, but she knows those battles. Higher education has always been on the back burner. The original laws, the old ones, the ones that Bryan pushed for, on their face, in the text, covered the state universities as well as the high schools. So it covered the University of Tennessee, for example. How much it applied there, you know, it's sort of debatable. I remember talking to E.O. Wilson, who became a very famous professor at Harvard, but was originally taught at the University of Tennessee. And he said, we didn't quite know what we could do at the University of Tennessee when he was a professor of it. He didn't quite know what he could teach on this subject. So it does become an issue. Bryan campaigned at University of Wisconsin to get it, and he had a famous debate with the president of the University of Wisconsin of whether they could ban the teaching of evolution at the University of Wisconsin. So it does come up. It certainly comes up to this day at church-affiliated universities. Many church-affiliated universities, some of which are credentialed to create biology teachers in high school, don't teach evolution for sure, or do teach creation science. Therefore, you get a ripple effect, and the studies of done by the American Association of Biology Teachers show that a significant minority of biology teachers, certified biology teachers in America, believe in creation science or believe in intelligent design, one or the other or both. And some deal with the issue. Many places, there's studies that show many places evolution origins is simply not taught because of local concerns or the teacher's feelings. Other places, there's a litany of battles of what teachers do teach. As I say, Eugenie follows those and knows those but those come up even right here in California. There's been a series of lawsuits brought by high school teachers in California, creationist high school teachers, to teach creation in California and in other states, in Minnesota, in all around the country.
Yes.
This question is particularly for Professor Numbers. I know that courts have repeatedly rejected the idea that creation science is just another form of science. And I think that was what you were arguing about with the lawyers the night before your deposition. But of late, I happen to be one of those people who subscribes to Acts and Facts, which is the monthly publication of the Institute for Creation Research. It's one of my great amusements. Anyway.
And it's free.
It's free, absolutely. I recommend it. Anyway, I've noticed that of late, quite repeatedly, not just once, but many times, they refer again and again to the Creator as Jesus Christ. Now, this is peculiar even in the narrow field of Christian theology, because one usually thinks of God the Father and not God the Son as being the Creator. Now, I wonder if that in itself is a demonstration of how very narrowly sectarian so-called creation science actually is and could not possibly be science.
I don't remember running across that because they clearly don't believe it in a literal way. It's God and not Jesus. I'd love to see the context for a statement like that because...
Well, they've said it several times in Acts and Facts.
Yeah. I need to read it more carefully, I guess.
I never thought about the question, but I think he's right. I've seen it.
I have a
Then
friend who says that this is called Christocentrism, where one essentially boils the Trinity down to just Jesus Christ. And I just wonder if that's a trend among creationists.
No. Generally, they would run from any non-Trinitarian, Unitarian. I mean, Unitarianism isn't even Christianity for those guys. For me.
I have seen him like that.
Other comments? Yeah. Yes.
Never thought about it.
I was a kid at the time during the Arkansas trial and later on during the Louisiana stuff. And I remember in the late 80s, early 90s, reading about it sort of in popular history. And the Arkansas trial always sort of took the limelight. And it seemed like the Louisiana thing was kind of an afterthought, maybe an anticlimax. And I'm wondering to what extent that was really true. For example, to what extent did the Overton decision influence or was consulted during the Louisiana trials, the Louisiana cases? And to what extent did the Louisiana cases seem, moot at the time because of the Overton decision? I just want some comments on that.
Question.
I'll let you go.
No, I was going to let you answer it, Patricia. Because I had obviously had the question before. Did the judge partly think that he didn't need to have another trial because there already was one?
My feeling was more that Judge Duplanche was concentrating on whether this was secular or religious, and that a large part of that had to do with his knowledge of Bill Keith and his background.
The simple answer is there wasn't a trial in Louisiana, so there's not a great story to tell.
But I've always had the question of why there wasn't a trial, why he just, and you're raising that he just assumed, he was assuming the result, because the issue really is creation science religion, not bad science, as Ron has pointed out. Is it religion? And therefore, since it's only religion, it's banned by the old pre-Epperson versus Aguillard, Epperson versus Arkansas decisions that you can't teach religious instruction, not about religion, but religious instruction. And so I always was curious why he didn't have a trial to bring out the issues as they did in Aguillard, I mean in McLean in Arkansas, because there they thought they needed a trial, and they went through the trial just as they did later on the issue of intelligent design. They had a trial in Dover, which brought out the issues, but the judge in Louisiana jumps way ahead, makes his decision on some grounds, which in some ways raises a problem that people have less digested what the issue is, so we haven't heard all the issues, and it seems like a ruling on high from a judge rather than something that has been worked out and we all get to hear the testimony. I assume that's going to come up in the later hearings, but any light you have to shine on that is helpful.
Well, Adrian Duplanche, who's now deceased, was not only the smartest judge on the Eastern District, he was probably also the most arrogant. And he had his point of view, and he was ready to roll, and that avoided a trial, which would have been a big pain. And he did his thing.
But to what extent?
I want to thank the panel very much. We now have break time. You wouldn't want to cut into that, would you?
No.
So thank you very much.